lie ahead. An endeavor has to be by all of us for securing justice for the last person in the remotest corner of the nation. I shall now read out the Law Day Charter, Constitution Day Charter. We hold that the law is the common heritage and trust of mankind. The administration of justice is one of the fundamental functions of the state, and judges and lawyers owe their allegiance by the traditions, training, and tenets of their noble profession to the cause and quest of justice. We believe that discipline of law is indispensably essential for the authoritative and peaceful resolution of all conflicts, for ensuring the orderly development of society, for maintaining the rule of law, for promoting social justice, for safeguarding liberty, and for protecting basic human rights and fundamental freedoms. We affirm that the independence and impartiality of the judiciary and the freedom and independence of the legal profession constitute the sheet anchor of social order, individual freedom, and equal justice in our society. We acknowledge the social responsibilities and the professional obligations of law in public interest and public service. We emphasize in particular the need to ensure equal and universal access of the people to the system of justice, especially to the poor, the weak, the deprived, and the downtrodden, the need for legal literacy and legal aid, and the need for social audit and evaluation of laws, and for scientific, rational, and pragmatic law reform. We pledge and dedicate ourselves on this, the Constitution Day, to the premises and postulates of this proclamation. With this, may I now request Mr. Pradeep Kumar Rai, Senior Advocate and Vice President, SCBA, to kindly deliver his welcome address.
Honorable Justice D.Y. Chanchud, the Chief Justice of India, Honorable Judges, Supreme Court of India, Mr. R. Venkat Ramani, Attorney General for India, Mr. Kiren Rijiju, Honorable Minister Law and Justice, Mr. Vikas Singh, President, Supreme Court Bar Association, Rahul Kaushik, Secretary, Supreme Court Bar Association, Mr. Rohit Pandey, Mr. Yugandhra Pawar Jha, Deepak Kanshal, Manoj Mishra ji is President Iskora, Mr. P.H. Parikh, 6-time President of SCBA and 10 times President of Iskora, former judges, senior advocates, members of the bar. This is the first time when we are celebrating Law Day on 25th of this month. However, 25th is also equally important because that was the day when the draft was finalized and handed over to the Secretariat of the Constituent Assembly to table it on 26th. And anyway, any celebration in relation to Constitution Day is actually a matter of pride for all of us, because it was Supreme Court Bar Association only which started this tradition to commemorate the Constitution Day and Law Day. For the first time in 1952, after the first amendment, our Supreme Court Bar actually celebrated Constitution Day, and thereafter in this lawn from 1973 by our President L.M. Singhvi. Earlier, this building was not there. It started on 4th August 1958. But prior to this building, the Supreme Court used to function in the Parliament House, and there it worked till 4th of August 1958. When I mention this, I always say that when we had a new building here in this part, what is the key features of this building? There is a sculpture made by Mr. Chintamani Kar, who was the greatest sculpturist. He created the oldest, the democracy, the youngest democracy in the hand of people of India, and that sculpture has a kind of structure as 6 as an open book which gives justice and equality to each and every citizen of India. Our motto is Yato Dharma Tato Jaya. When I mention this, I always feel that our judiciary is actually a kind of protector of Indian Constitution. Our judiciary has actually upheld the integrity of the nation in the eyes of entire world, because they know that our democracy, our judiciary is completely independent of anything, and because of that they are capable of actually in rule of law and protecting fundamental rights. Sadly, post-independence, judicial infrastructure has not been overhauled to meet the demands of growing needs of modern India. Especially, I will draw attention to Honorable Law Minister. He must assure and he must think that this has to be overhauled. Though there are so many other things are happening, we recently learned that Central Vista is already in place, Parliament House is being shifted. So originally where our court was there, you can give it to us. We can actually start functioning from there where our court was there. It will meet all the needs of our bar, meet all the needs of our judges and the institution. And when you actually do something for the bar and for the litigants, you will be remembered as a successful law minister. There are so many other demands of the bar. This is not the occasion, but when I feel and when I see that there are so many lawyers, they don't have chambers. Lawyers like us, we don't need chamber. I never applied for that. But when I see that so many members who come here with the hope that they should have some place to work with dignity and they don't get it, it is so painful. It is not the story of only Supreme Court. Each and every court has similar problem. On 26th, when Baba Saheb Bhimrao Ambedkar, he was handing over this document, he said that a constitution is like a machine of a lifeless thing. It acquires life because of the men who control it and operate it. And India needs today nothing more than a set of honest men who will have the interest of the country before them. So these words of Baba Saheb and then Mahatma Gandhi's talisman, in which he said that when you make a policy, you should always consider the last man of the society, and if your policies are not actually benefiting the last man, then it means there is some problem and we are not actually serving the interest of the nation. Indirectly we can say कि ऐसे तौर तरीके हमें भाते नहीं जिसमें न्याय गरीबों के हक में आते नहीं. I always say and I believe Ramdhari Singh Dinkar's those lines in which he had said, न्याय नहीं तब तक जब तक सुख भाग न नर का सम हो, नहीं किसी को बहुत अधिक हो, नहीं किसी का कम हो. All these things are there. There are so many other issues which has to be dealt. Now the time has come, because this in democracy we have to always keep one fact in mind, that there should be free and fair polls. There should be rights of citizens should be protected. And if you spend, honorable law ministers come from Odisha Pradesh, where even a MLA's election costs 50 crores. So if that is the budget, if that kind of cost of the service is there, then obviously the person who is contesting is not aiming to do the service of the nation. I request honorable law minister that he should consider the demands of judiciary, the collegium, whatever they are recommending, that you should accept, because if this issue has been settled. It has been settled by pronouncements. It has been settled by several opinions, and now this system is working very well. If you have any doubt, again you have to consult the judgments which has been delivered by Honorable Supreme Court. I request you that you are senior most person in the law ministry. You should never make a statement which embarrasses anyone, because honorable judges, they don't have medium to say anything, but bar will certainly respond to it. I really welcome, sir, each one of you. Law minister is very well known to me, and I feel that he will not mind whatever I had said, but I request you, sir, that these vacancies should be filled, because you see what is the ratio. If you are considering comparing with the developed nations, In all the developed nations, the ratio of judges is 170 per million, and we have sanctioned 21 only. And in these 21, around 30% are vacant. How can you consider all this? You have to think in a positive direction. You have to support Honorable Justice D.Y. Chanchud and our honorable judges so that the system is more strengthened. It is actually, then we can deliver the justice, dispensation of justice will be better. Thank you so much.
Thank you, Pradeep sir, for raising all the issues. May now request Mr. R. Venkatamani, Learning Attorney General for India, to kindly deliver his address.
Why do we congregate year after year? To remember the Constitution. I think every day we walk into the court, I feel part of a great motion of belonging to the commitment to the most deprived sections of a community, the least and the disadvantaged sections of a community. And remember that the Constitution itself is a social justice document. Social justice is not part of the Constitution. Constitution itself is a social justice document. And that's why we want to congregate year after year, to be part of living with the Constitution. And this living with the Constitution means it commit to each and every value that infuse not only what the Constitution does today, but what made our freedoms possible. We live in freedom today because hundreds and hundreds of people laid their blood and sweat and toil, lost their liberties. And therefore, when you say living with the Constitution means we pay a great homage to those long line of people who made it possible for us to live in freedom. When I came here in 1979, February winter, walking into the court for the first time from a faraway place in Pondicherry, the court looked a very distant space. It looked a huge building, and it took me some time before I could gather what it means. Of course, now I can say I have substantially gathered what it means. And I'm sure each and every one of us, with your own years of experience, would have gathered what it really means. And one thing which I think very deeply all of us will be committed is that access to justice is the cornerstone of the Constitution. And if Supreme Court is a pillar of access to justice, it makes it so in so many ways. It navigates all those difficult areas of the Constitution to ensure that access to justice is always available in as many possible ways and means one can conceive of. I think I just want to take only a few minutes time. I don't think I should talk at length about Mr. Rai has proposed certain things. I second him. That's a good way of seconding before the Law Minister. And the first cry of an infant being born is the announcement of a long journey. The family jumps with joy. The mother forgets all the burdens she might have weathered. And that's how it was when our motherland got her freedom. And that's how it was when the nation announced to herself the birth of the Constitution. A proud moment, and the national imagination awakened to the long journey of our people. We are part of the long journey. I always think when a new institution is created, those who enter the institution at the time of his birth are part of the growth of the institution. And those of us who come at a later point of time are part of the history of the institution. And therefore, the greater responsibility on us that the birth and the history in our hands are safe. COVID brought us for a larger number of other concerns to be addressed. The world and the country is addressing many of those concerns. And if you look at the transformation from the colonial administration of justice, which we inherited through the Constitution and a large number of legislations, we have a certain set of ideas about what is justice. Therefore, we have a legal education which is merely legal education and not justice education. I think slowly we have moved away from these concepts. I'm sure sooner or later we will have only justice education, not legal education. What do I mean by that? I mean that the contours of our understanding of law and its relevance to people's life and liberty must be core, and the core of it must be justice. I just flag few issues and then conclude my speech. Now we have rooted to a physical space as a court system. We are also looking at the adversarial system as the only means of delivering justice to people. We need to move away from this understanding that the justice needs of different sections of a community are wide and varied. You can't put them in one straight jacket. On the contrary, over a period of time, our legislation looked at them from some fundamental common notions, and we are now stuck in that. Therefore, we need to move far away from that, how to really evaluate the justice needs of different sections of a community, and to restructure fundamentally our court system, our law framing, our law reforms. I think a lot of things to be done. Having been in the Law Commission, one final request to the Honorable Law Minister, I think it's time we have a permanent Law Commission, and a permanent Law Commission which will be assisted by the best quality of experts in our country. All the bar in our country, the High Court, various High Court bars, are the cream of layers and talents available to tell us in what directions reforms can be taken forward. I think if the Law Minister and the bar, putting as much pressure on the Law Minister as possible, can move in the direction, I think we're on a great journey. Thank you for your attention.
Thank you, sir. May I now request Mr. Vikas Singh, President SCBA, to kindly deliver his address.
My Lord the Chief Justice of India, Dr. D.Y. Chandrachud, Honorable Law Minister for India, Mr. Kiren Rijiju, Learned Attorney General for India, Honorable Judges of the Court present here, Law Officers of the Government of India, Vice President of the SCBA, Mr. Pradeep Rai, Rahul Kaushik, our Secretary, members of the Executive Committee of the SCBA, Manoj Mishra, President SCORA, and members of the Executive Committee of SCORA, retired Judge Justice Indu Malhotra present here today, senior members of the bar, ladies and gentlemen. Our constitution is very unique because when the Constituent Assembly was constituted, the idea was that the constitution will be given by the people to its people, and that's why it starts with the preamble, we the people of India give to ourselves this constitution. But under our constitution, the unique responsibility to uphold the constitution is given to the judges of the higher judiciary. If you will compare the oaths that the judges of the Supreme Court take vis-a-vis the oath that a minister takes or the oath that the President of India takes, there is a stark difference. Judges say that we will uphold the constitution and the laws. And in 75 years of our independence and 72nd year of our constitution, if there is any threat to the good running or to the smooth functioning of the constitution, it is only and only if the judges do not uphold the constitution and the laws as is the expectation of the people of this country. And how do we ensure that the judges do uphold the constitution and the laws? The best way to do that is to appoint the best people as judges. When the first judge's case was delivered, where the collegium system was thought of, the justification in the judgment was that we as judges of the court know the lawyers. We know who's what in the profession. And accordingly, we are the best to choose for the higher judiciary. And that's how the power, although the constitution did not vest in them for appointing judges, they asserted this power and took this power. Till the judgment remains, that's the declaration of law, and our constitution is really an embodiment that rule of law is primary in our governance. If the judgment has not been upturned, everybody has to follow. But if the judgment gets upturned, or if there is a new law brought in, which I have suggested, and I have given it, in fact I have drafted a law also on a bill to regulate the collegium system, probably according to me things can improve, and I am not so charitable to say that this system is working the way it was originally conceived to work when the first judgment was delivered. Unfortunately, there is hardly any effort to find good lawyers. There is no system of identifying good lawyers. There is no transparent method of identifying who will be the right person to be elevated. And I say this with a sense of responsibility because this is my third tenure as the President of the Supreme Court Bar, and in spite of my struggle for the last, in all these 3 years, for getting members of the bar elevated to the various high courts, I have been unsuccessful because I am told that the high courts don't know our lawyers, so how do we compel them to appoint them? My very straight answer is that it is their duty to find out where are the best lawyers in the country. If they are not doing their duty of trying to find out the best lawyers wherever they are, then the whole basis for assuming this power is clearly, according to me, can't be justified. You have to make this system more credible. Initially I had no problem with the collegium system, but you have to make it more credible. You have to either, if the government is not ready to bring in a law to regulate the collegium system, the judges have to bring in a system in place in-house, which assures to the nation, to the legal community, that the best are being picked up in a manner which justifies that the entire process is transparent and fair. But while this judgment holds, while this judgment is being followed, has to be followed because that is the rule of law in this country, then the recommendations of the collegium system have to be honored. It's unfortunate that the government is disobeying the rule of law by actually not making those recommendations which are reiterated. When there is a litigation, one side loses. Every day we lose. But nevertheless, we respect whatever has been decided. That's the rule of law. The government may have contested that this system is not correct, but ultimately they lost. And if they have lost, then the law of the land is what the judgment says. And if the judgment says that upon a second reiteration, people have to be appointed, it has to be done. And the government can't be seen of violating the rule of the law. In the Supreme Court, we have seen that sometimes appointments come within 2 days, sometimes it takes weeks together. There should be some uniformity of honoring the recommendation of the collegium. It can't be that the government can start doing pick and choose and saying that this one we will go ahead and appoint and the other one we will not. That system has to change. Either they are able to do it in a legal way by getting in a better system, but if they don't have a better system which according to them will work, they have to obey whatever is the law as laid down by our judgments. According to me, if this constitution has to remain as a relevant document, has to actually be an interface for delivering to the people of this country their rights as guaranteed in the constitution, then that can only be secured by good people manning the higher judiciary. So I on this very, because there is an apparent conflict which is quite obvious everywhere, that names are being recommended and not being appointed. This, according to me, is a complete negation of the rule of law, and I beseech the Honorable Law Minister to please ensure that this negation doesn't happen anymore. Thank you.
Thank you, Vikas sir, for raising all the important issues, especially lawyers practicing in this court, to be considered for elevation to High Court. This may now request Honorable Mr. Kiren Rijiju, Union Minister for Law and Justice, to kindly deliver his address.
Honorable Chief Justice, Dr. Justice D.Y. Chandrachud, Honorable Judges of the Supreme Court, Mr. R. Venkatramani, Attorney General of India, Mr. Vikas Singh, President, Supreme Court Bar Association, Mr. Pradeep Rai, Vice President, Supreme Court Bar Association, Mr. Rahul Kaushik, Honorary Secretary, Supreme Court Bar Association, Mr. Rohit Pandey, Joint Secretary, Supreme Court Bar Association, the members of the Supreme Court Bar Association, and all the lawyers who are attending this very important gathering to observe the Constitution Day, which we are going to celebrate tomorrow. But you have a tradition that you will gather here on the eve to observe this very important day. Now, when we achieve certain milestones, we look back at the journey, how we achieved the long, successful journey. We have seen some of the apprehension when India gave itself this constitution, and even before that, many people question about the wisdom of the great people of India to manage and survive as a successful democracy. Today, India is standing tall. The entire global community are admiring the success of Indian democracy and the emergence of India as a global leader. There are certain parameters for that, and those parameters are important, but I'm not going to delve into it in a serious or a very comprehensive manner, because that will sound like seminar. But I would just state a few facts. When we talk about success, there are people behind the success. We have seen the failures around India. We have seen how the system is overturned. We also have seen the uprising in many parts of the globe. When India succeeds and survives as a thriving democracy, we must salute the great people of India for the success of democracy in our country. The basic character of the people of India is democratic. That is why we rightfully claim that India is the mother of democracy. We may have taken many things from different countries as a matter of experience sharing, but we cannot discredit the great contribution made by the people of this great country. To make an institution or a system successful, we must also ensure that the people who are in the system and people who are in the institution must be given due credit and recognition. A country progresses under the visionary guidance of its leaders. If the leader becomes weak, naturally the country becomes weak. If the Chief Justice of India is made weak and vulnerable, it is also amounting to weakening of the Supreme Court itself. If the Supreme Court of India becomes weak, it amounts to weakening of the Indian judiciary. I would like to salute Dhananjay Chandrachud on assuming the position of the Chief Justice of India and laid down his vision. I have read it in few of his observations and also shared a dice with him when the Bar Council of India honored him, felicitated him, and I have learned that under his stewardship, the Supreme Court of India will ensure that the great tradition of Supreme Court of India and Indian judiciary will raise to a new heights. In a similar manner, we have many organs in our country. We respect all the organs. We respect all the people who are managing those organs. The Prime Minister of India, being the elected leader of the country, is not a leader of a political party. He may belong to a political party, but after assuming the elected highest position of the country, then he becomes the leader of the country. If Prime Minister is respected, honored, certainly the image of India will also be enhanced. Today, I have seen across the globe how our leader is respected, because the mandate given to him by the people of India is the reason why our leader is respected. In the last 6-7 months, I had many interactions with my counterparts. If you talk about England, which is same pattern of law we follow, the common laws, I had 3 discussions with 3 different justice ministers. We planned out to have another dialogue, and next time I found the minister is changed. So here, the stability in which the people of India has been entrusting the responsibility to the government is also a matter for rest of the countries, rest of the world to understand and see that India is truly a thriving democracy. We have seen the instability which weakens the country. That is why we must not undermine the power of the people. The power of the people is the ultimate power. The sovereignty lies with the people of India, and we have to stand by that. We draw our inspiration, our authority, and all our guidance from the Constitution of India. So on this very important, auspicious occasion, I once again commit myself to abide by the spirit of the Constitution in true sense. We all are law-abiding citizens, and we have to ensure that this particular success story of India is carried forward for all the times to come. Constitution may have been amended, but the spirit of the Constitution cannot be changed. And I think the founding fathers of Indian Constitution have thought out very well, and we are moving on that direction. And I can assure you, in our government, under the leadership of Prime Minister Narendra Modi in last 8.5 years, we have not done anything to undermine the authority of the Indian judiciary. It is going very well, and also the amount of coordination and cooperation which government and judiciary is having, it is paying dividends, it's showing results. I am also committed to creating better infrastructure in the country, but there are certain shortcomings which rendered all of us to a situation where we have found ourselves to be in a very limited circumstances. For example, the High Court, they manage the infrastructure issues of the High Court, and the lower judiciaries. Now, Supreme Court cannot interfere into the affairs of the High Court, nor Supreme Court do anything about the infrastructure in lower judiciary. The only thing we could do together is when we meet in a conference like Chief Justices and Chief Ministers, we raise this issue and try to come together to settle those pending issues. Because High Court not being the subordinate to Supreme Court, the only thing where Supreme Court is higher than judiciary is that Supreme Court can review the decisions of the High Courts. So I know the limitation of the Supreme Court, and many times Supreme Court judges also have mentioned about the worrisome conditions of the judicial infrastructure in the, especially in the district and lower courts. I am very mindful of it, but I must honestly share that despite the best effort, the funds allocated are not being utilized. The large numbers of pending of the funds allocated for creation of lower judiciary infrastructure is something which is very troubling for me. And I have been constantly pursuing the state government as well as the Chief Justice of the High Court that he must give enough emphasis on creating better infrastructure. That is so important, and especially in the far-flung districts and tehsils and the lower administrative centers, the judicial infrastructure definitely is not adequate. But we have made substantial allocation of budget. Last year we extended the lower judiciary, the infrastructure budget, which is called central sponsored schemes for lower judiciary. We are very mindful for that. And at the same time, I would like to give my commitment that we will work together as a team. And tomorrow, Honorable Prime Minister, Honorable Rashtrapati, both are going to share the celebration in the inaugural as well as the valedictory function. We will also get to listen to both the Honorable President and Honorable Prime Minister, and also Honorable Chief Justice will be sharing the event. And also there are I think two or three technical sessions. Some of the senior judges will also chair those sessions. I am very happy that Justice Chandrachud, being the person who has steered the E-Committee of the Supreme Court, has done tremendous job, and he has really taken forward the Digital India campaign launched by the Government of India. And ultimate aim, as a law minister, I want to see very soon the Indian judiciary goes paperless, so that we really understand the benefits of going into totally digital mode. There are many things to share my opinions, but this much is enough, because tomorrow we are going to celebrate the great occasion, and the learned Attorney General and our Solicitor General both are there. I will not get into the legal issues because they are our commanders to deal with the subject in the court. But on the policy matter, from the Government of India's side, we will always be there to support, strengthen the Indian judiciary, and also to ensure that the independence of Indian judiciary is untouched and it is also being promoted. We will always be there to guide with each other, as has been said many times that we are the offspring of same parents. हम सब कहते हैं कि एक ही संविधान के कोख से जन्म हुआ है, चाहे वो न्यायपालिका हो, चाहे विधायिका हो, चाहे कार्यपालिका हो, हम सब एक हैं, भाई भाई हैं, आपस में लड़ना झगड़ना ठीक नहीं है। हम लोग मिलकर काम करेंगे और देश को मजबूत बनाएंगे। थैंक यू वेरी मच। जय हिंद।
Thank you, sir. Our country has come a long way in the last 70 years, and I guess the credit goes to our founding fathers, members of Constituent Assembly who had the foresight for all this. Good to know that the government is taking proactive steps to improve the infrastructure in the judicial infrastructure in the country. With this, may I now request Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India, to kindly deliver his address.
My very distinguished colleagues in the Supreme Court, Justice Sanjay Kaul, Justice Ajay Rastogi, Justice Jiten Maheshwari, the Honorable Union Minister for Law and Justice, Shri Kiran Rijiju, Shri R. Venkatramani, Attorney General for India, Mr. Vikas Singh, President of the SCBA, Shri Pradeep Kumar Rai, Vice President, Mr. Rahul Kaushik, Honorary Secretary, Mr. Rohit Pandey, the Joint Secretary, Yugandhara Pawar Jahan, the Treasurer, my very distinguished former colleague and sister, Justice Indhu Malhotra, Solicitor General, Mr. Tushar Mehta, the law officers who are here, and all the distinguished members of the bar who are present. Why do we meet on the eve of Constitution Day to celebrate this event, and what is this great significance that we feel towards the Constitution that leads all of us to congregate here in such a large measure? You have the text and the letter of the Constitution, the bare book of the Constitution, which we handle in the court, which is given to us every day. We have the judge's interpretation of the Constitution, the judgments which we as judges deliver. Then there is the citizens' engagement with the Constitution, whether it be on the traffic light, whether it be in the election of the members of the legislature in the states or in the center, whether it is in terms of their demand for better health facilities, whether it is in terms of their expectation of a good and clean environment, and good education for their children, secure conditions of living, safety for their families. But then in our court, there is a dialogue over the unfolding of the Constitution which takes place every day between the lawyers and the judges. That, to my mind, for us in this community of judges and lawyers, and we have also allowed the law minister entry into this community, very closely guarded community. This dialogue about the Constitution between judges and lawyers every day, this defines how the essential values of the Constitution unfold in the lives of our citizens. And those values are the values of dignity, equal respect for citizens, our sense of fraternity towards each other, and above all, liberty and equality. Every day in the court, seemingly small issues pertaining to our citizens, whether it is someone's quest for pension, someone's quest for bail, someone's quest for a job which has been lost or which has to be secured, someone's quest for admission to a medical college. All these small, seemingly small issues actually unfold the working of the Constitution. Many other Supreme Courts across the world would be somewhat surprised at the kind and diversity of the issues which our Supreme Court deals with. A very distinguished judge of a foreign Supreme Court who came to visit our court once told me that I was in the court when there was a dispute over a telephone bill. He said, well, our courts will never consider raising an issue pertaining to a telephone bill in the highest court of the land. Well, there may be two questions as to whether the Supreme Court of India should be resolving telephone bills in the Supreme Court. And it's quite a debatable question. But the most important thing which we need to realize is that our courts have a different place in our society. And the Constitution has so configured our courts so that we form a part of the lives, the daily lives of our citizens. And therefore, if you see the way our judges in the Supreme Court, in the High Courts approach the work which they are called upon to do, no case is too small for our judges. And I dare say no case is too large. Because ultimately, you apply legal principles to every case, however small, however large. But it is in the application, the equal application of the same legal principle to every citizen of India, that we generate a sense of confidence, that those who do not have voices are heard in our courts, those whose faces would not find expression outside may be heard and seen in our courts. So it is in these interfaces between our bar and bench, in our daily lives, in the course of our working, that we unfold the true and intrinsic worth and merit of our Constitution. 26 November 1949 was a very significant day because that's the day on which the Constituent Assembly adopted the Constitution. The drafting of the Constitution was a historical event, encapsulating the rights, the liberties of our citizens, and the dreams and aspirations of our citizens. But above all, our Constitution is an exercise in nation building. And that process of nation building is a constantly evolving task that is never static. The Constitution as we see it today is very different from the Constitution which even the framers of our Constitution imagined it would be. And I dare say, long after we have laid down our jobs and our lives, the Constitution will be very different from what we imagine it is going to be today, because the Constitution is constantly evolving to meet the new social realities of the time. The Constitution has a very important role for the judiciary, and can you imagine a judiciary without the lawyers? When you talk of the judiciary, you must understand that the bar and the bench are equal stakeholders in the process which goes on in our court. When we as lawyers and judges interact with each other, we send one very important message to all our citizens. And that message is that in this mission of providing justice to our common citizens, we stand together. As judges, we come and occupy these offices for the term that the Constitution gives us. But never do we as judges ever believe that we stand apart from the bar. And never does the bar believe that it stands apart from the citizens. So though we have a discipline of our own in the law, our law has its own logic, sometimes which is not understandable to citizens. Though sometimes the phrases which we use in our judgments may not be found in dictionaries. Yet, in this mission we stand together as members of the bar and the bench. And it is that hope, it is that mission which I bring to you on my first Constitution Day since my assumption of office. Now, the confidence of our citizens in the judicial process is also determined by how efficient we are in the way we organize our work in our judicial institutions, not just in terms of the important judgments which we deliver. For the citizen, ultimately it matters with whether their case is heard by the court. How long does the court take to hear their case? By my distinguished former colleague, Chief Justice Uday Lalit, to refine the listing process with a view to bring down the pendency. We are trying to ensure that defects are notified to advocates on the same day that a case is filed. After taking due scrutiny of the working of the registry, we have taken several remedial measures. In taking these remedial measures, I consulted all my colleagues, because I do believe that every one of the judges of the Supreme Court brings a great and wide experience as lawyers first and foremost, as members of the district judiciary, as Chief Justices of the High Courts. And I've tapped that experience of every one of my colleagues. The result now that we are able to verify about 200 matters every day, as opposed to less than 100 matters a few weeks ago. Last Sunday, every member of our listing department, the listing section 1B, stayed back the entire Sunday to clear the arrears of matters. So we must also remember our own registry. In just the last 5 days, the registry officials have worked relentlessly to verify 982 matters. This has ensured that the time required to notify defects has been reduced from 9 days to 2 days. Currently, as of 5 p.m. today, we do not have any matter filed prior to the 24th of November for which defects have to be verified. From the next week, every bench of the Supreme Court will hear 10 bail applications preceded by 10 transfer petitions. There are about 3,000 transfer petitions pending in the Supreme Court. Since we have 13 benches going on right now, our endeavor is to dispose of around 130 transfer petitions every day before the vacations. We also want to ensure that bail matters are listed and disposed of in an expeditious manner, as that deeply impacts upon the personal liberties of our citizens. Apart from changes in listing, we are also trying to set up specialized benches in the Supreme Court to provide speedy remedy to litigants. From next week, 4 specialized benches will be functional in the Supreme Court to deal with motor accident claims tribunal cases, criminal appeals, especially those where the accused are still in jail, land acquisition matters, and direct and indirect tax matters. You will realize that each one of these 4 or 5 categories of cases deeply impact our citizens and their right to speedy justice. So the choice of the category of these cases is also based on the need to deliver justice to our citizens. We need to expeditiously hear motor accident claims because they involve very often simple questions relating to the loss of life and personal disability and the computation of compensation. But where citizens are waiting for years and years for a compensation claim of 5 lakhs or 7 lakhs or 9 lakhs. Disposal of criminal cases is also priority for me because these matters essentially involve questions of life and personal liberty. As we celebrate Constitution Day, I also take the opportunity to reflect on the role of the bar in protecting and evolving constitutional values. Several judgments of our court on constitutional law are considered as landmarks. But these judgments of our court are built on the arguments which are presented by lawyers and the ideas which are presented by lawyers. So in that sense, the writing of the judgment is a sense of the dialogue between the bar and the bench. Members of the bar therefore play a crucial role in bringing novel interpretations of the Constitution before the court and in facilitating the evolution of the constitutional process in India. In drafting our Constitution itself, several members who are members of the Constituent Assembly made their seminal contributions. If we look at the last 75 years since the independence, the contributions made by the distinguished members of the bar across the country are enormous. But the contributions of the bar must not be considered only in the context of the evolution of the jurisprudence by the Supreme Court and by the High Courts in India. Thousands of lawyers working in the trial courts help citizens at the very first stage of the legal system. They work without any social security. COVID brought us into stark reality of how little in terms of social security our lawyers have. Yet they soldier on. While the Supreme Court and High Courts can decide constitutional questions, the working of the Constitution is also dependent on how the processes at the district level are operating. The Constitution works when a citizen is assured of adequate legal representation at the very incipient stage of our legal system. If someone is denied adequate legal representation at the trial level, it is the constitutional right to be heard that is denied to that person. Therefore, as the Chief Justice, I appreciate the role played by the bar across all levels. the Constitution is not just a legal document. It has a social dimension. It has a political dimension. Therefore, the understanding of law cannot be divorced from social reality. We must acknowledge that law in the past has also worked as a source of oppression. For instance, the Criminal Tribes Act criminalized millions of tribes whom we know now as denotified tribes. The social law of the time treated millions as untouchables. When we celebrate the Constitution every year, we must be conscious of the histories prior to the adoption of the Constitution. Therefore, the values of our Constitution must be understood and evolved in the sense that the law no longer acts as an instrument of oppression. And it is tasked to every young member of the bar, every senior member of the bar, and every judge to ensure that the law becomes a source of justice and not a law which becomes a source of injustice. Lawyers around the world have used the potential of the Constitution to win rights for the citizens. The experiences around the world show that the building blocks of people's rights are built through several individual cases. Public interest is thus served not just through PILs, but also in ensuring that citizens have smooth access and experience with the justice system. I therefore call upon the senior members of the bar to take some pro bono cases of poor litigants every year. This practice can be institutionalized, and I am open to a dialogue on it. I also endorse the idea that the curriculum of law schools needs to be evolved so that even the law students can be involved in the facilitation of the legal process. The working of legal aid clinics together with the bar needs to be redesigned to ensure that law students can learn as well as contribute to real cases happening in the courts. This can happen by conceptualizing a scheme where their roles are institutionalized at the district or trial level. From the success stories of legal aid clinics across the world will emerge a new effort to merge legal services with the legal aid clinics in the law schools with the bar. Young law students are full of optimism of our changing world, and we must facilitate the channeling of their energies into their holistic learning as well as in the pursuit of justice. In its constitutional goal towards access to justice, the Supreme Court has been improving its processes with technology, but the court needs cooperation and assistance from the members of the bar in making the court's processes accessible. As we march step by step towards an era of e-governance and online courts, the Supreme Court Bar Association can consider organizing training sessions together with us in the E-Committee for members of the bar in acquainting with the new processes. In particular, it may be difficult for lawyers who come from outside Delhi and from the neighboring regions for their cases in the Supreme Court to be aware of their procedural requirements. Members of the SCBA may take a lead in creating online educational videos which can help lawyers coming from outside Delhi. In terms of technology, the young members of the SCBA are tech savvy, while the young members are taking mentorship and lessons from the senior members of the bar. They can in return assist their seniors in having a smooth experience with online systems and processes in the courts. But we need to create a culture in the bar where lawyers across India are guided and mentored. All of you have come from different parts of the country and made this institution a thriving institution. You have to give back now to others from across the country whom you need to mentor as well. The legal profession is often described as a noble profession, but it must not turn into an elitist profession. Rather, as a constitutional goal, it must support diversity. The constitutional goals ought to be realized in the working of the profession as well. We must have a culture of compassion and dialogue within the legal profession. Society is changing, and so are our institutions. In the area of the Constitution, we must now shed away the legacy of colonial thought and culture within the legal system. We have to make our legal system truly adapt to the local needs, demands, and aspirations of our citizens, including in the language which we use. As they say, that practice begins at home, the legal profession must shed away its colonial underpinnings. In a country like India, where summers include extreme heat waves as a result of climate change, we must reconsider the strict dress code for our lawyers, particularly in the summer. I'm not saying that our dress code should be done away with completely. Of course, there is a decorum of the court, but I'm just floating the idea of making our dress more compatible with our life, our weather, and our times, so that there is a meaningful discussion on this. In particular, the strictness on attire should not lead to moral policing of women lawyers. The discourse on the Constitution can evolve when lawyers have access to court judgments easily, as their arguments are strengthened by citing precedents. I'm particularly concerned by the struggles of young members of the bar who are optimistically joining the profession, but have no means to access judgments and report books. As Chief Justice, I am working towards updating the Supreme Court reports in a timely manner. The copies would be made available online free of cost, so that they would be accessible easily. The law clerks are an integral part of the court now. They assist the judges with extensive research. The Supreme Court judges' library staff cooperate with the request for research material in a timely manner every day, so that the court discussions are made smooth. As Chief Justice, I am trying to see that the judges' library is updated with the latest databases. I am also thinking of having an online remote access to the library database, so that the law clerks can easily access the resources and that the burden on the library staff may be reduced. Members of the academia often complain that there is a lack of communication between the profession and the academia. Well, I consider academicians to be a part of the larger legal fraternity, but as a gesture of my belief, I am considering to set up an annual Supreme Court of India lecture series on the 28th of January every year, as 28th of January 1950 was the day when the Supreme Court came into being. We will invite a distinguished jurist from other jurisdictions to facilitate academic discussions on the global trends on constitution and the legal systems. Finally, criticism about the collegium. I thought I had reserved the best for the last. No institution in democracy or in a constitutional democracy is perfect. But we work within the existing framework of the Constitution as it is interpreted and given to us. And all the judges of the collegium, including me, we are faithful soldiers who implement the Constitution. When we talk of imperfections, our solution is to work our way within the existing system. Because we as judges are entrusted with a system which we have to abide by and follow. The President raised a query about, are good people, how would you get good people to man the system? Getting good people to enter the judiciary, getting good lawyers to enter the judiciary, is not just a function about reforming the collegium. Getting to be judges is not a function of how much salary you give judges. However high you pay your judges, it will be a fraction of what a successful lawyer makes at the end of one day. People become judges for different reasons. People become judges because of a sense of commitment to public service. There are some doctors who join private corporate hospitals. There are others who spend their lives working for the All India Institutes of Medical Sciences, for the public hospitals to serve the poor. So becoming a judge is a call of conscience. And getting good people to become judges is first and foremost about inculcating upon the minds of the young members of the bar about the limitless ability which lies in the power of every judge to do good to society. Good judging is about being compassionate. Good judging is about understanding the problems of people. Good judging is about not being judgmental about people whose ways of life you and I may not agree with, including somebody who is in breach of the law. Good judging is about understanding why even a criminal becomes a criminal, which is not to excuse the crime, but to ensure that even when you deliver hard letter justice, there is a defining line which ensures that within the framework of the law, there is a great power which is entrusted to the judge to be of good to others. And I think when we need to have good people within the system, the answer lies somewhere else. And that answer lies in mentoring young people by giving them the ability, the dream, the aspiration to become judges. Not in pursuit of a better life as a judge, or by having that car which the government gives you, or by giving that house which the government gives you. I think that's the least important part of the job, because that's all very transient and it's all going to leave one day. But what leaves, something which does not leave you as a judge, even when you retire, is that sense of fulfillment. Your conditions of service are only so long as you are a judge, but something which is never taken from you even when you demit office is your sense of fulfillment of what you have done for the community during the time that you have been a judge. So I think it's also about changing the culture in the minds of our young lawyers. And we have to make judicial office appealable to our young lawyers by the way we work as judges, by the way we work as lawyers. If young lawyers see senior members of the bar screaming at judges, young lawyers will feel, well, do I want to go there and be screamed at by other members of the bar? On the other hand, if young lawyers feel that judges are given such respect by all segments of the establishment, that will only make judgeship more appealing to them. Likewise, we have to ensure that young lawyers are mentored by our judges. When we as judges mentor young lawyers, we get more than our adequate share of blessings in terms of the smiles which they give you, in terms of the kindness which they show to you inside and outside. When I was down with a very florid attack of COVID in May 2022, I got an email from a group of women commanders in the Indian Navy to whom we had delivered justice. Brother Rastogi and I were on the bench, and then Brother Imarsha and I took the mantle in another case. Those women commanders sent me a little email and told me that, sir, you have never met us in person, and I'm sure we'll never meet you again in person. But for the justice which you did to us in our case, we are all praying for you and for all other judges in the Supreme Court who have been afflicted by this rather serious ailment which we are all combating in our society today. That, I believe, is the greatest satisfaction of judging. So it is when we share these stories, that's when we will encourage good people to come to the bench, encourage them, tap them, ensure that they accept judgeship, persuade them. And in this task of persuasion, a great deal of mentorship is involved. So it's not just about reforming the collegium, it's not just about giving better salaries. Of course you have to give better salaries, because their cost of living has to be attended to when their children are growing up. I know that. I've brought 2 children up over a career spanning 22 years. But there is something much more fundamental about attracting good talent to the bench. And I thought I must highlight that. And last, the Chief Justice is only the first among the equals. I am blessed as Chief Justice with very dynamic, responsible, considerate senior colleagues with whom I engage every day. So much of the work of the collegium takes place when an agenda is circulated. But so much of the work of the collegium takes place much earlier and much thereafter. When we leave over a cup of coffee, when we share a thought over a cup of coffee. So you must also understand that there is something called a soft culture within the judiciary as well. And we as judges are not really here to only follow the letter of the law by following the processes of the collegium, but for the purpose of ensuring that the soft culture, that sense of constitutional statesmanship between the government and the Supreme Court continues to be in harmony to find the right balance in the selection of judges. We can't be constitutional statesmen if we are only at a point where we are finding fault with each other. We understand that we have a system, we have a constitution, and we need to work our way as constitutional statesmen to finding just conclusions. And I'm sure that with the assistance of very distinguished colleagues who I have on the bench, who have great experience of handling difficult situations, we can handle every situation with a great deal of harmony and social resolution. Thank you very much.
Sir, it was excellent hearing you. Our constitution is still evolving, and it's on this Constitution Day, it's also time to remember our stalwarts of this profession, Mr. Palkiwala, Mr. Seruvai, who had appeared in Keshavananda Bharati that the basic structure of the Constitution cannot be amended. Sir, you are taking proactive steps to improve listing, having specialized benches, having SCR online free of cost for young members of the bar. We are extremely grateful to you. May I now request Mr. Apur Om. He is a special child, son of one of the lawyers, Mr. Vikas Chand, practicing in this court, to present a portrait to Honorable Chief Justice of India and Mr. Kiren Rijiju, Honorable Union Minister for Law and Justice. It's a long-standing tradition of the SCBA to honor members of the bar who have completed 50 years of practice at the bar. May I now request Honorable Chief Justice of India and Honorable Union Law Minister to kindly present shawl to members of the bar as a token of respect. May I call Mr. Shri Amlan Kumar Ghosh, who has completed 50 years in the bar, to kindly come on the stage. May I request Mr. Amlan Kumar Ghosh. May I request Mr. Amlan Kumar Ghosh? May I request Mr. Ashok Kumar Sil? May I request Mr. Satish Vij, who is sitting here? Mr. Satish Vij, who's completed 50 years in the bar. Sir, please come. May I request Mr. Ashok Bhana also to kindly come on the stage. He's completed 50 years in the bar. And also Mr. Harpavan Kumar Arora. उधर से उधर